Welcome to the additional podcast called Divorce Tips, where I answer some of the most asked questions regarding before, during, and after divorce. These are 10-minute golden nugget episodes to give you as much information as possible from a divorce expert. That's me. Let's go. Welcome to another episode of Divorce Tips. Today we are talking about mediation. I think this is a really important topic because 99% of all divorces that end up being litigated are going to go to mediation. And there's a couple different kinds of mediation, so you kind of have to be aware of that. There are a lot of collaborative mediation out there, or collaborative law. There, you kind of have to know a little bit of the difference, but there are mediators out there that you can then pay a package deal where you can go, you don't have your attorney, and you then go and you specifically meet with the mediator with your ex, and that mediator helps mediate out the agreement, and then they write out the documents that you then file with the court. That's full session mediation, and usually you don't have an attorney. One of the reasons why I want to just kind of caution you on that, most of the time those mediators are not attorneys. They are licensed mediators for some reason. So they're really good at the communication part, at getting the parties to understand and get back and forth on communication to kind of get a deal. But what they are not is they are not lawyers, and so they cannot give legal advice. So you have to remember that, because a lot of times these mediators are going to just do whatever they can to get you to settle. But the mediation doesn't make sense in reason or law because it's not giving you legal advice. So I always encourage, if you're going to go that route, absolutely support it. If you don't feel like you need to go as hard as hiring an attorney, but you need to go and meet with an attorney for at least an hour consultation so you can ask your questions and that attorney can give you information regarding case law for that state. And by doing that, you then go into mediation knowing a little bit about the statutes and what you can expect. And so you can better be equipped to protect yourself, your future, and your family when that mediator is not. That mediator is not your advocate. It's not your lawyer. They're going to do whatever they can to get you to agree. So that's like doing mediation without an attorney. Now, in Utah specifically, if you file for divorce, you have to mediate before you can go to trial. And even though I'm a high litigious firm, so most of our cases are litigating, we resolve about 95% of our cases before they go to trial. But sometimes that happens after 3 episodes of mediation, 2 years of fighting. Sometimes we have to go to court. It all just depends. And usually in these cases, when we go to mediation, the opposing party has an attorney as well. And so that mediator is a neutral party going back and forth about trying to get deals. But your attorney and their attorney are your advocates, making sure that your rights, your future, your family are advocated for. And then giving you advice on, hey, I think this will work, or no, that's completely unfair and this is why. And then giving you a little bit of an analysis of, hey, if you go to court, this could be your outcome. If you don't go to court, if you settle now, this makes sense because your risk to benefit ratio is, good here. So you kind of want to look at that. And a couple of things I want to talk about mediation is divorce is super emotional. I don't care who you are, but it is tough. And she wants to make sure when you are talking about mediation, if you go to mediation too quickly for these very emotional issues, you're not going to be able to settle. Because pushing somebody that is still in that high denial stage, that high emotional state where they can't make rational decisions, is never going to be a good idea. So my philosophy is we don't push mediation too quickly. I want to make sure that my clients are ready to actually negotiate and get deals. And I don't want to have to be that attorney to push you there, especially when you're not ready. So there is a little bit of strategy of not going to mediation too quickly. There are some cases, yeah, let's go to mediation. Let's see if we can get this done. But some cases, no, we need to do some discovery. We possibly need to go to a court hearing first because we need to get some things resolved before, we can actually go and mediate. And then there's those cases where, you try to go to mediation, you think that your case is fairly reasonable and that you'll be able to settle. An opposing party is just absolutely unreasonable. And those cases are hard because they're, I'm not going to encourage my client to settle for an absolute unreasonable settlement when if you go to court, I believe that this is what will happen. So there's a lot of strategy that goes behind how are you going to settle at mediation. Now, usually in mediation, there's ways that this can work so you don't even have to sit in the room with your spouse. You guys could be in separate rooms and the mediator goes back and forth so that you don't have to see your ex. And a lot of times, especially with attorneys, that's the way we do that because our cases are high litigious. Now, if you don't have attorneys, you and your spouse are on good speaking terms and you just need to go to a mediator, sometimes maybe you can sit in a room. Technically will help things go a little bit smoother, but you have to be careful to bite your tongue and not be rude and you have to be ready to kind of be adults in that room, which sometimes is so hard when you're going through this, really, really emotional time. Our mediations though, the way that I prep our clients to go to mediation is I tell you to think about 3 things. What do you want? First of all, you're never going to get what you want in divorce, but it's good to know what you want, what you're willing to settle for, and what's your bottom line. You have to know those. You have to know those 3 levels because that gets us to settlements. No one wins in divorce. You're always going to walk away thinking, did I give too much? But the other side is always going to be thinking that too. And I always say the best divorce settlements are the ones where both walk away thinking, did I do okay? The other thing is that if you walk away and you're like, okay, I didn't love that settlement, but I can live with it, that's a good settlement because you're never going to get what you want. You're always going to get, somewhere in between. And so you want to make sure you know your 3 levels so it gives you an opportunity to settle. You're going to have to move the needle. The other thing is you really have to know what's most important for you. Everything can't be the most important thing to you in a divorce. So you're going to have to really prioritize and state your top 5 things that are the most important. Those are the things then, and rank them 1 through 5. That number 1 thing, that's then what you don't compromise on. But everything else, maybe you have to give a little to make sure that you get that one most important thing. But you're never going to be able to get there if you don't know what it is. So work on that. List your most important things and make sure when you're going into mediation, you know that, hey, I'm not giving this up. And this is why. The other thing is you have to be able to let the small things go. You just have to. Sometimes mediations are so exhausting. We get done with all the major big things and then we end up spending 2 more emotional hours over Christmas tree ornaments or the teapot. And I'm just telling you, when we get to that position, everybody's tired. Everybody wants to be done. And I just have to look at my clients and say, you have to let these small things go. Everything's replaceable. There are some things that are not replaceable, and those are considered major things like pictures. But everything being digital now, we can always get you a copy of your pictures. So those are the kind of things you really have to think about, and you really have to just be okay letting go so that you're not spending 2 hours of your attorney time, 2 hours of the mediator's time, which is going to end up costing you probably about $800 on little things that you could replace with that $800. So I want you to go into mediation prepared. I want you to be protected. And I want you to make sure that you go in there knowing that you're going to protect yourself, your family, and your future. You got this. Thank you for listening to this episode. If you enjoyed, please subscribe, follow, and share. I'd love to hear your questions and feedback. You can contact me at community@jillcoil.com. See you next time. I am an attorney, but I am not your attorney. Any advice given on the podcast is general and shall not be construed as legal advice.